second round. Thank you, Mr. Chair, and thank you to the witnesses for being here and bringing your expertise on such an important topic. And Mr. Dupeau and Fowler, thank you for your service to Canada. The Justice Deschamps recommendation number 8 with regard to civilian and military prosecution frameworks says it allows recommending to allow victims the choice to request, I prefer to use the term survivors, but allow victims to request a civilian or military prosecution. Mr. Fowler, could you speak to that? I've heard from multiple survivors that they are seeking this as an option for Bill C-11.
Well, what we have to remember, and I think people forget this, is that for the past 25 plus years since the enactment of Bill C-25, which provided jurisdiction under the Code of Service Discipline for sexual misconduct arising within Canada, is victims, survivors, complainants, whatever term people want to use, have always had that option, right? There's been concurrent jurisdiction since 1999 for people to bring their complaints to the military justice system or the civilian criminal justice system. And as I've said before several times, the first decision maker when it comes to enforcement of criminal law relating to sexual misconduct, the first decision maker is not a government decision maker. It's not an investigator. It's not a prosecutor. It's not a lawyer. The first decision maker is the complainant, him or herself, the victim, the survivor. They get to choose, as it stands right now, notwithstanding policies that have been promulgated by the previous ministers of national defense. The complainant gets to choose whether the process is going to be in the criminal justice system, the civilian criminal justice system, or the military justice system. What this does, what Bill C-11 does, is it takes that option away from them. And the fact that many complainants, many survivors, went to the military justice system, and some to this day say that they'd prefer to go to the military justice system because it makes sure that the military is informed of their complaint and can take action, are going to be deprived of that because of Bill C-11. We have to remember that the Code of Service Discipline doesn't operate as an independent silo. It operates in a larger mosaic of enforcement within the Canadian Forces, along with other disciplinary regimes and along with other administrative regimes. And I will tell you right now that if the military justice system is deprived of prosecuting sexual offences arising in Canada, the chain of command will still feel compelled to act. The only problem is they're going to be using those tools that are available to them that are ill-suited to prosecuting sexual misconduct. They're going to use administrative reviews under DAOD 5019-2 to prosecute allegations of sexual misconduct. And those aren't suited to contesting or testing contested evidence, right? So what Bill C-11 is going to do is it's going to tell those survivors who want the military justice system to deal with their complaint to go elsewhere. And when people are dissatisfied with the civilian criminal justice system and the outcomes there, what then?
I may as well follow on to that. Since December 2021, the criminal offences of sexual nature have been transferred to civilian courts. Have you seen any data on how many cases have been sent to the provincial system? And do you know if any of those have been thrown out due to the Jordan framework?
There's relatively little public data, and I know the Canadian Forces is tracking this. They're not making it public, which one questions if the whole point of this is transparency. But there have been cases that have been rejected due to delay, including some high-profile ones, right? Those of you remember the prosecution of Lieutenant General Trevor Cadieux in Kingston, which is where I'm from, and that prosecution was stayed for delay. And Justice O'Brien of the Provincial Court of Ontario, who was the presiding judge, delivered a judgment that was scathing about the conduct of the military police in continually dragging their heels to provide disclosure to the Crown, which then prevented the Crown from disclosing that to the Defence Council. And to add insult to injury, the then Canadian Forces Provost Marshal attempted to blame the Crown Attorney for the delay, when the delay was very clearly due to the military police. Right? There's a consistent theme throughout many of the prosecutions that have gone sideways, both in the military justice system and in the civilian criminal justice system involving members of the Canadian Forces, and that is failures by the military police. Bill C-11 isn't going to fix that. And it does need to be fixed, and my colleague Colonel Drapeau has mentioned some of the failings of the military police. The core of the problem is holding leaders accountable for inaction, bad decision-making, or overreaction. And as has been alluded by some of the other witnesses, you can't legislate good leadership. You can't legislate culture change. What you can do is have legislation that allows you to hold leaders accountable. A perfect example are, and Ms. Duval-Antoine has mentioned, and I agree with her, that there needs to be time limits, limitation periods for people to take action, to appoint key personnel, even to provide reports. The Judge Advocate General has been consistent.